Hello everyone, my name is Dmitriy Aristov. I'm a business, entertainment, and estate planning attorney in Los Angeles, California. I run my own practice called ARISTOV LAW PC. It's located in El Segundo. My contact information can be found below or throughout this video. So today I wanted to talk about the basics of arbitration. And this is a term you might have heard before and maybe you didn't. But if you check almost any contract that you've ever gotten into, including any contracts online, any contracts where you bought a car, where you bought something else, where you signed up for some kind of a service, almost always at the bottom of this contract, there's a clause that says that you waive your right to a jury trial and you agree to binding arbitration. So what that means is that you actually are not permitted to take your case to court. Instead, you have to demand arbitration and go through the arbitration process in order to resolve your dispute regarding this contract. So think of it, so it's a clause in a contract, and it's very, very common, and most likely anything you sign up for has that clause in it. So what is arbitration and what are its basics? Well, that clause really determines your ability to pursue any kind of dispute, and it can determine the rules by which you pursue that dispute. For example, if you select JAMS or American Arbitration Association rules, that will have different rules based on to resolve your contract. So, and there's also binding and non-binding arbitration. So binding arbitration means that is it, meaning you can't do anything else. All you can do is take this decision by the arbitrator and bring it to court to enforce it. So how does arbitration work? Well, what happens is that there's these associations and companies that basically provide arbitration services. And they're usually through a retired judge who will then take your case and you will submit all the evidence from both parties to this neutral arbitrator who's going to then try to make a determination or ask for further evidence or further statements from both parties in order to try to resolve this matter, at the end of which he's going to issue a resolution. And that resolution may be actually binding if that's the clause in the contract, okay? And so it's still kind of a costly process. Arbitrations run anywhere from $5,000 to $10,000 just for the arbitrator himself. And then you have to pay your own fees for your attorney to represent you, or if you represent yourself, of course. And then the other thing is that at the bottom of that arbitration clause, check to see whether it says that the prevailing party will owe attorney's fees or not. So basically, if you win, you're gonna get your costs and fees for attorneys reimbursed. But if you lose, you have to pay the other side's attorney's fees and costs. So please double check that. And so what arbitration really is that it really incentivizes parties to try to enter in some kind of a settlement. And often parties, right before the arbitration proceedings begin, or when they're set, if they can come up with some kind of agreement, they usually do. And the first thing the arbitrator usually does is says like, hey, have you guys tried settling this before? And so it really does incentivize settlement, and it's an informal procedure that's not submitted to court. So as a result, you get this done faster and potentially less costly than, for example, going to trial. But arbitration can also cost a lot of money, so keep that in mind. And if the arbitration resolution is not followed, then you take that arbitrator's decision and actually submit it in court by filing essentially a lawsuit and saying, I want to enforce this arbitration agreement. And how you start these arbitration proceedings, and the reason I'm talking about this is because a lot of my clients, business clients, clients that have a contract dispute, they really don't know where to go from here. So they have a disagreement, and then they don't know what the next step is. And the next step, if you have this arbitration clause, is really to send a letter to the opposing side to demand this arbitration, and then to say, please send me a list of arbitrators. That's a good tip to get things moving so they don't just ignore your letter. And give them like 30 days to answer your demand. I hope this video was helpful, and as always, feel free to contact me. My contact information is below and should be throughout this video. So hope to talk to you again soon, and thank you for tuning in. Bye.